This will constitute the meeting of the Zoning Board of Appeals, Tuesday, August 3rd at 7:02 or 3 p.m. And sitting as a Board of Appeals so far are myself, Woody Chittick, as chair, Lee Darst, Matt Watkins, Dave McMorris, vice chair, and Mike Dickey. And call to order. The board business, all we have are meeting dates. I know of no conflicts personally. Does anybody so far? That should motivate us to move one of those two dates. If not, do I have a motion to accept tentatively the meeting dates of September 7 and October 5th?
I second motion.
Okay. All in favor?
Aye, Lee Darst.
All right. So the first item on the agenda is a continued hearing on 147 South Main Street.
Woody, I apologize. We do have other board business, and I know you want to get to David.
What's that?
I did amend the agenda and let you know that 12 Margin Street, the decision is expiring next month, and due to COVID, they are getting ready to file for a building permit. They have filed the decision, and they're just asking for a year extension.
A 2-year time limit they have?
Right. And they're just requesting a year extension, and we can do that with a vote. And I'm sorry to interject, but
given what Jen has told us, is there any discussion about the Margin Street, which was a relatively modest? Was this a second story expansion or something?
Right. They filled in a back porch and up a bit. It's a little bit up. Yeah. But it was a
modest
Rockwood
expansion on a modest house.
Yes.
But anyway, we had granted it.
You did.
Questions on the part of the board? Like more background? I don't personally see any harm in extending it a year. It's only been 2. And COVID has certainly knocked everything kind of into a cocked hat. So I'd make a motion that we grant the request to extend the 2019 special permit for another year.
I'll second it.
Okay, moved and seconded. All in favor? Woody Chittick, aye.
Lee Darst, aye.
Dave McMorris, aye.
Michael Dickey, aye.
Matt Watkins, aye.
Okay, moved and seconded, Jen.
Thank you very much. I appreciate that.
Whoops. Well, let's start. We've just lost poor Dave, but at any rate, let's find out if anybody is here to speak for, or the hearing is still open. So if anybody is here to speak for or against the application with new information.
I'm signing off at that. I'm
Lee Darst is recused.
Correct. So I have promoted Jeff Hassett, and I'm trying to promote. So Scott Golding is playing the part of Attorney Adam Brodsky this evening. I'm just trying to promote him right now. He's there. And of course we have Cindy Amara from our council, and Mr. Shibo is here as well. And Patricia Fisher, and the architect as well. All right, okay, I got everybody.
All right, so we've temporarily, oh no, Dave McMorris is back. Dave, you want to lead the way? I think what I'd like to hear is new information as opposed to an affirmation of the applicant's application. But those of you who are, it's Jeff, Sam, etc., Patricia, John.
Oh, yes. Sorry, Mr. Chairman. This is Scott Golding from Drouin, Totua, Morgan. As Ms. Oram said, I'm filling in for Adam Brodsky this evening. I'm representing, our firm represents John Schiavo, trustee of the Schiavo Family Trust. I know the board is well aware of this project as it's had multiple hearings, a significant amount of information submitted into the record, as well as significant amount of testimony into the record. We do not have any new information to submit to the board this evening. Our hope is that we can close the public hearing, move towards a vote. We've already received the approval from the planning board as well as approval from the Conservation Commission. We can certainly answer any questions the board may have, but I have no new information.
Well, we will, after we hear any, have any dialogue here, we'll move to close the hearing and begin deliberations. But does anybody on the board have further questions to ask of the applicants or his representatives? I do not. Anybody in the public, Jen?
There is no one in the public, and there's no one in the Q&A.
Okay.
Jen?
Yes,
My understanding is the only new material that we've received since the last hearing is the 18-page submission from Ms. Goodson.
that's correct. She came and dropped it in, and I scanned it and got it to all of you.
Okay. No, I didn't see any explanation of what point she was trying to make with it, but I guess we'll just deal with it as we look at it.
Right. She reviewed it a bit with me. If you'd just like me to give you a quick synopsis, and essentially all those photos were taken by the insurance company after the fire. If anybody hasn't seen them, they're posted on their website. But they were just showing the view from her second story. She was trying to show height, and then she drew the footprint of the building as she said she knew it. And those were the explanations.
Okay, thanks.
You're welcome.
Anyone else? Well, I would make a motion to close this hearing.
I'll second that.
Okay, moved and
McMorris.
seconded. Sorry, somebody said something?
It was me, I was identifying my second.
Oh, okay. Woody Chidick, aye.
Dave McMorris, aye.
Matt
Michael
Watkins,
Dickey,
aye.
Okay. So we got Mike and Matt, both ayes? Okay, so the hearing is closed. Let's, because of Dave's situation, with everybody's approval, move on this one application to the deliberation phase. Typically, we conduct all our continued hearings and then hear a new hearing, and then we deliberate. But in this case, we may not have the benefit of Dave's presence for the evening. So due to illness, not other.
Can we do that with the agenda?
Can we do that, Jen?
I believe you should vote to amend the agenda to vote it up. I mean, it's all set time-wise, but just so that there's a motion to move it next, to keep it cleaner, even though it's the timing is fine because
Yeah, okay. I would make a motion to move the deliberation on 147 South Main Street as the second order of business tonight, or at least hearing business tonight. So it's been moved.
I'll second the motion.
Okay, all in favor? Woody Chidick, aye.
Michael Dickey, aye.
Matt Watkins, aye.
Okay, so we have 4 of us. Sorry to pull you guys out, but nevertheless. Okay, so board, we have a draft decision in front of us by Dave. And Dave, do you want to talk to us a little bit about any of the sticky issues? I noticed that in your draft decision, you left a number of placeholders for our decisions, but didn't presuppose where we might come out as a board. So maybe you could take us through those various placeholders.
Okay, I thought that the most recent one that I circulated had all that filled in.
Well, maybe so. The one I have. Anyway, doesn't have it. Sorry, did anybody, am I the only one dealing with an earlier version?
I think so, Woody.
Okay, let's go with the conditions. I can catch up real fast.
Okay, I actually am looking for a copy of it on my phone because I'm not home. And my computer's in for repair. First, I mean, I in looking through all of the evidence that we've taken in the submissions, I think there are a number of very positive things that developed during the course of the hearings. I think there are a number of changes to the building itself, including taking the balconies that were facing the Main Street residents off the design and moving the balconies around to the Spring Street side. when they redesigned the interior to add the bedrooms on the third floor, it didn't change the exterior profile of the building at all. I thought the fact that the building is now conforming in all respects, and including the lot coverage, which before was somewhere in the 60%, is now going to be conforming. I thought all of those were substantial improvements in the structure and the property itself. The other major issue that I think that we want to look at is the change in use. It was a non-conforming use as an auto body shop and residences. It's now being proposed as a non-conforming use as for commercial space and residences. It's not, our bylaw 8.8 allows us to issue a special permit to do that for essentially two different reasons. One, that there's no substantial change in the character of the use, which I don't really think applies here, because I think the change in the non-conforming use is substantial. I think it's substantial in a good way, but it's still substantial. I'm looking at the second branch of 8.8, which says, or in its effect upon the neighborhood and vicinity. And I don't think that there's any substantial negative effect on the vicinity at all with this change in use. So I think we're fine. And I think it's advisable to issue a special permit under 8.8. As to all the flood issues, this is going to be a flood compliant building. The other one wasn't. And the lot coverage is actually being substantially reduced. So it meets that prong of the flood bylaw. So in sum, I think that the changes that the owner has made during the course of the hearing to accommodate a number of the neighbors' concerns, which include, by the way, I think there's probably going to be a substantial improvement in stormwater management from this property. It's all pervious material now. The water just runs off it and goes elsewhere. It will now have a lot of pervious area where the water will stay on the property and into the groundwater. And what does run off is going to be managed rather than just running off wherever it does now. I think the lighting plan should address the neighbors' concerns because it should not have any spill beyond the property lines. The big issue for me is the parking. There was a lot of discussion about the parking throughout the hearing and whether people had parked in the front, whether people had parked in the back, or how close it was to the property line, all of those issues. What the issues boil down to for us in parking now, essentially, is that there is 1.5 spaces at the front of the property, which are non-conforming with the 25-foot setback in the parking regulations. I think that the evidence that we've had pretty well establishes that area has been used for parking in the past for however long. I do think that use of that for parking is grandfathered, and in any event, it's pretty minimal. All the parking throughout the lot is now set back the required 5 feet. So other than that 1.5 spaces, all the parking is conforming. The other issue with the parking, of course, is that under our bylaws, there are 3 residential units, which requires a total of 6 parking spaces. There are about 2,300 square feet of commercial space, which would require an additional 23 parking spaces. So 29 would be required under our bylaw. The proposal is for 17. And that, I think, is the biggest problem with this proposal. I can certainly envision a number of commercial or retail uses for the property that would require a considerable amount of traffic there all at the same time. The examples I put in the decision are nail salons, hair salons, where there are a number of employees that need parking and a number of patrons that would be there at the same time. It would require parking. I therefore think that it's important that we condition the decision with a restriction on how the commercial space can be used. I know when the proposal was originally presented to us, it was envisioned as professional space, CPAs, therapists, that kind of use. And I have no doubt that that type of use, there was adequate parking as proposed for that type of use. So I suggest that we condition the decision to be used for professional spaces only, and that any other types of use they want to make come before the board for a further review. Other conditions that I proposed, I'm trying to recall.
Well, one of them, I found my decision, one of them was anything more than the most negligible field changes
Yes.
come before this board. Right?
Yeah, I think it's I think being in the middle of a residential neighborhood like this, design that we have, I think is a good design. I think it meets the neighbors' concerns. I think that any departure from that design could be a problem for the neighbors, and I want to make sure that nothing gets changed that could impact the neighbors in any way from what we have now, in any negative way. So I would like to see there's obviously some field changes that may come up that are minor to accommodate things on the ground as they develop the property. And I'm sure that the building inspector can handle that. Anything more significant as to appearance or use should come back to us. Also, the conditions of the 2 as-built plans to be filed. The one question I did have is whether we need to include in the decision that all of the existing impervious surface be removed before the project begins. Obviously, it doesn't do any good to put down a pervious asphalt over a concrete slab. So I would like to make sure that the property is cleared of all the impervious surface before they do the construction. I don't know if we need to require that because it does seem to show that on the plans, but I did want to put the question out there. And I think that's pretty much all of my thoughts on it.
Yeah, you also wanted to see documentation of affordable housing
Yes,
designations as a condition. Mr. Chavo has offered, of course, to have one of the 3 units as affordable, but we'll need all that documentation.
yes. And I do want to make sure it's a condition that there is an affordable unit there.
I would have one addition and then another. I don't know if it's a good idea or not. I mean, frankly, I'd like the board's opinion on that. But under 4, copies of as-built plans must be filed. I'd like to put a time on that, and that would be before an occupancy permit can be issued. So that, I mean, technically, he could file something 5 years hence. I don't know that's not his intention, but I think it's just good language to have.
Yeah, I think we should have a boilerplate
Yeah, I do too.
that we put in all of these decisions. It
Yeah, and
says-
usually it's 2 sets of as-built plans, so that if we
Yeah,
need to circulate them to other boards for affirmation.
Yeah, I added that. I haven't
Okay.
circulated. I did add that. So it'll be 2 both of as-built plans should be filed before an occupancy permit is
Yeah,
issued.
which is not obviously a burden at all, but at least it puts a time frame around when those have to
Okay.
come in.
Yep.
The question I'd like to ask the board is, so now we will approve, presumably, professional spaces here. Should there be opening and closing hours? I mean, I don't want to sort of impair or anybody's business model. You know, you don't have to be out of there by 6, but should there be a 9:30 closing or 7:30 opening? I mean, I don't know, or is that too intrusive? I asked the board. Any opinions?
I don't know.
What do you like? Do we know any of the other like professional spaces and town? And I know this one's in close proximity, but would it be,
We never asked the question. So there may be, it's a little late to get the
yeah. I
data.
do know we talked with Adam, early in the hearings about, whether it was a 9 o'clock or a 10 o'clock or an 8:30 or whatever it was. We did have some conversation on that, but I'm just thinking out loud, even like in my own office, if it's just a few people doing professional work, if there's a deadline for me to get out of the office by 9 o'clock just because of that rule, it you know what I mean? That's a little bit unusual compared to, if there's 15 people still occupying the building at 10:30 at night, then that's a problem, but I think it could be considered a little much of a reach if it's
Yeah.
a curfew on, being out of the building at a certain time.
Particularly,
I think
Go
if
ahead.
you're going to have a restriction to avoid retail, then the issue
Yeah.
probably isn't as important. And I'm just thinking, say a CPA is in there. I mean, come tax time, they're probably going to stay late. That's what CPAs do in April, right? So
right, and beyond their desk light, I mean,
yeah.
nobody's going to know they're there.
So it seems to me that hours of operation restrictions would make sense if there was some kind of retail
Yeah.
establishments going in there. But because you already have the restriction against that, then I don't, having hours of operation restrictions seems to me to be overkill.
And I think if they do want to put in some retail, they do have to come back to us, and we'll have an opportunity at that time to consider whether a restriction is necessary.
Cindy has her hand up. Is that correct?
She's muted.
The only thing I would say is also, to the extent that you allow professionals to be in their office after hours, which is when they're likely to want to be there on occasion, if it becomes a problem, you'll hear about it and you can bring them back in and revisit the issue.
Without formal opening or closing hours?
You can just have them in for an informal meeting and say,
Yeah.
we're getting complaints. Do we have to reopen this hearing and have a hearing on whether we need to institute
To
formal?
modify the conditions or to put more definition?
Yes, so I think you will know if there's an issue.
Okay, to my mind, as long as this isn't engraved in stone, and if there were, as Cindy said, a problem that we would start with the informal discussion and see where that takes us. I'm comfortable. And I think if the right kind of people are in there, right kind of businesses, not people, but businesses, as Mike says, this really shouldn't be a problem. And it's probably much more compatible with the neighborhood and probably much more in the final analysis rentable space than if you had a real mixed bag of businesses. I don't know, but anyway, any contrary points of view on tenancy? If not, I mean, really, I'm not trying to shut anybody off, but
So
No, I thought it was a very well-written decision. I thought that the conditions, really helped to get us to where we wanted to get to be, more comfortable with the whole thing. And I might have one or two things that I could send you, David, but the only sentence, if you will, that I was going to suggest to add to the conditions, and it is kind of lumped in. So number 2, when we talk about, strict attention to the plans approved, obviously the stormwater, the light, the lighting spillover and the landscape plans are part of the plans. So that's kind of included in there, but I wondered if we should add a sentence that says, this includes implementation of, the stormwater control, lighting, spillover, and landscaping plans, just to make sure that that's part of the actual building set plans if
I can
that's
add that.
needed, so.
What do you think? What do you all think about the pervious, impervious issue?
This is part of the plan. If they don't make the, I don't know, Dave, if they don't make the 30%, the plan is not being implemented as approved. Now, if you want to specify, you could always say in that condition and add, the owner must, where are we? Copy all, no, not all built. Any changes beyond the most negligible must come before this board. That's number 2, including conversion of a 63% impervious lot coverage to 30%.
Okay.
Otherwise, it invalidates the approval, I think. Cindy, you have a point?
If you're going to, my opinion, if you're going to include language, including, you should also include language, but not limited to. So either leave it blank as it is, because it's a pretty bald statement, or if you want to include examples to make sure they're aware, then just make sure you leave yourself, make it perfectly clear that you're not limiting it to that. That's all.
That's easy. Okay, Charlie Higginson. Charlie, you're muted. He had his hand up, but Charlie, can you hear me? I guess not. Jen, can you deal with that kind of offline?
Can you hear me now?
Yeah.
Okay. Sorry, I just joined, but I was listening. I just couldn't get the Zoom to work. I had a couple of just sort of editorial changes. The following conditions, what follows aren't the conditions are further on down. I would say following 4 conditions each time that's met, though now you've added a condition, so it'll be 5. And the other thing that worried me was that we say this was appropriate for the grant of the special permit, the parking. I don't think we discussed what was the appropriate parking. I'd rather use the word permissible.
Okay. Other points of view? Anybody want to probe further with Charlie in that? Any problems, Cindy, or is that okay?
No, I think permissible is fine, because that's really more of a neutral statement as opposed to a judgmental statement.
Okay.
And we haven't seen like the conservation decision, right? But I think that would probably be more of the authority or the oversight with if there's any sort of soil contaminations or anything that are discovered during pre-construction. That would be an action for the Conservation Commission to monitor.
Well, yeah. Hey, Dave, where is the boilerplate language that deals with meeting the conditions, bylaws, and conditions of all other boards having jurisdiction? Did I glance over that? Go over that?
I'll add it in.
Okay. Yeah, the 2 boilerplate additions would be that, and this is for everybody in the board's benefit. And the before an occupancy, the 2 sets of, not 1, but 2 sets of as-built plans before an occupancy permit is issued. That just, again, puts a time frame around everything. And it does deal with that question about stormwater and other things. Obviously, they can't subsequently fail to receive a permit from the Conservation Commission or somebody, and still have an eligible or an approved plan. But
Yeah, because I feel like, for example, like the pre-characterization of soils is sometimes a condition that you see, but it's not one that this board would.
right.
Typically
All we want to
perform.
know is, did it get a thumbs up or down?
Yeah.
Yeah. Okay, board?
Okay.
These are good ads. Okay, well, I'd make a motion to accept the decision as drafted and amended. In our discussion, people have very small grammatical error or whatever corrections. I have literally one, changing a has to is, but we can deal with that tomorrow. I'll email Jen and Dave the very minor, not worth discussing.
We just
Yes, Jen.
determine who's determining who's voting on this matter. Charlie said he was here and heard everything. I just want to make sure that I have that we put that in the decision.
Okay, well, I was here, Dave was here, and Charlie was here then.
Okay.
So the three of us will decide. I'd make a motion to approve the decision, as I said, as written and amended tonight. And tomorrow.
Second.
Okay, moved and seconded, all in favor?
David McMorris.
Aye.
Okay, Dave McMorris, aye, Charlie Higginson, aye, and Woody Chidick, aye. Okay.
Thank you all very much.
Yeah, thanks.
Thank you.
Dave, just give us a sign if you have to leave.
Okay.
We have our next, extensive hearing, and followed by a discussion in a while. 488 Jerusalem Road. This is for a special permit to construct a covered porch, dormer, and roof at 488 Jerusalem Road. So our people being promoted, Jeffrey DeLisi is here online. Lee, are you recused in this one too? No, okay.
I'm here.
Yeah. Lee is here. John, thank you and your team for showing up. Okay, you're muted, but I see they have none. Yep, okay.
All right. So I have Jeff promoted. And I don't see anybody. Oh, we're not promote Ryan.
Yeah, Ryan is in the air. He can't make it. He might be late, but
I see him. I'm promoting him now.
Oh,
Could you also promote Mr. Cavanaro, please?
Sure.
Thank you.
Okay, so we'll open this hearing on 488 Jerusalem Road. So the first up will be the Wyndham's and their attorney. And then we'll hear from Attorney DeLisi and/or his client. Yes, Jen.
So it's a special permit. So that Jeff applied for.
I'll defer. I think that's
Okay. I just wanted to make.
Okay. I'm out of sequence.
But if Jeff wants to, I just want to make sure because I get confused. It's a lot on this address.
And I'm fine going first or having Jeff go first, and I can add in my response to his, whichever you all prefer. It's fine with me.
Woody. Why don't we have Jill go first? Because until I received the submittal, I wasn't planning on saying anything. So I'm just gonna comments basically in response to her. So
Yeah. Okay, Jill, you're up.
Sure. Thank you so much. Good evening, members of the board. My name is Jill Mikesell, and I represent the Wyndhams, who are abutters to Mr. Stadco, located at 482 Jerusalem Road. I'm not going to rehash my last submission, but I do want to briefly address a few key points that are critical here. And otherwise, I'm going to rely on my prior arguments and papers submitted to the board. First, I just want to note that as I mentioned at the last hearing, I had submitted exhibit
Terrible
1 and
time
2.
joining.
Wait, Charlie, you're not on mute. Sorry, Jill, go ahead.
Oh, no worries. At the last hearing, prior to the last hearing, I had submitted on July 12th an exhibit 1, and exhibit 2, which were drawings that were created by Mr. Cavanaro and his firm. Those drawings, especially exhibit 2, highlighted that Mr. Stadco had failed to accurately represent the scope of additional nonconformities caused by this project, as detailed in the drawings. At the last hearing, there was some question about the accuracy of, in particular, exhibit 2. And so I'm going to go ahead and finish what I have to say, but I would like, if the board would allow me to, to have, Mr. Cavanaro wasn't able to make the last hearing, but he's here tonight. So I would like to have him address the board with respect to Exhibit 2, and particularly in light of the fact that the veracity or the accuracy of that drawing was questioned at the last hearing. Before,
Wait a second, Jeff, did you have your hand up? You're muted, so I can't, it's not gonna do much good.
I have my hand up. I just see this being very circular. I expressed my concern about something like this the last meeting. I at this stage, I don't think that we need any further. I would object to any further submission or presentation by Mr. Cavanaro, anybody at this point.
Okay, well, I think that new submissions are out of the question tonight, and I'm only interested in new information. If this is a reiteration, we've been there, done that. I want to hear something new, or if an allegation was made at our last hearing, I think it's legitimate for you to address it tonight if it was not addressed then. But only if it was not addressed then.
yeah, and I would just say, with respect, Mr. Cavanaro has been at every hearing. He was unavailable that evening, and I wouldn't ask for him to speak to it if the veracity of it wasn't questioned. And I think all of our goals here, and I'm sure your goal, is to get this right. So again, I'd like for him to address that. I'm not sure whether you're saying that.
I don't think, wasn't aware that veracity had even come up in our discussions. It might have to do with methodological differences. That has nothing to do with veracity.
I think there was, I don't want to go back too far here, but there was a question as to whether the blue shaded area that Mr. Stasco had identified as being the additional nonconformity by which is the subject of this special permit application actually told the whole story, or whether or not the additional shaded areas that was shaded by Mr. Cavanaro and his firm were actually the portions of the project by which Mr. Stasco needed to request further permission. I mean, the issue goes to what is he requesting a special permit for, and it's our position that what he's requesting a special permit for, he's understating the scope of his request. And I think
but you've submitted that already.
I have, correct.
Well, I don't think we need to hear it again. I would like to have new information presented to this board. I think we've all read probably much more than we wish to, have gone over exhibits after exhibits and things. So we're familiar with what was not only submitted, but what was discussed. I'm just not interested, personally, I'm interested in something new, not something old.
That's fine. I'll go on. If Mr. I don't know if Mr. Cavanaro has anything new to add to that, but I don't know, John, do you want to just?
Good evening, members of the board. I wasn't, without going beyond what you'd like me to say at all. I was here primarily to cover anything that you thought was incorrect. And I think the whole point of the last exhibits that we prepared is to just articulate that we think that the volume increase in the non-conforming areas that was stated as 2.7% by the applicant's architect was far below what actually was being presented with their drawings. So that was really the gist of it, that the volume within the setback was far understated from what their own drawings showed.
Do you disagree with his methodology, or the premise, or the basic premises that?
Well, we're not privy to their actual methodology. They just state an existing volumetric volume within the setback, and then they state a % increase based on a square footage of roof that was elevated just on the peak portion of the house and not the expansion of the roof on both sides.
And well, both sides, there's probably no dispute that one side it's outside the setback, correct? So that would be legal regardless.
Mm-hmm.
Then the issue probably comes down to the dispute between what is the front setback.
Well, no, even agreeing with what has been determined by the board, say conceptually, as the 18.2, their drawings don't reflect the amount of volume that's being increased with the present house that exists today based on their drawings.
And have we been given that explanation visually?
Yes, you've
In
been
the
given,
exhibit?
it's been presented, I think,
All
to
right.
the state.
And that's my point, Woody, is it's in the record. I frankly can't remember the substance of the conversation, if at all, if at all I came off as questioning Mr. Cavanero's veracity. That would be a massive mistake, because I think he has the utmost veracity. So it's really probably just a question of interpretation with information that's in front of the board.
Mm-hmm. Okay. Go on, Jill. What more do you have?
So, I'll take it from here. So as you all know, I made a submission last Tuesday. You had highlighted and expressed an interest in the issue of substantial detriment to the neighborhood and the manner in which there's a substantial detriment to the neighborhood here. And I made that submission in the hopes that I could elaborate on that question that you had. I think most importantly, my submission, and I'm not going to, again, rehash what I've already stated in there, but it highlights and demonstrates that it's certainly within your province and power and supportable in light of the facts to deny Mr. Stasko's special permit application. Mr. Stasko fails to meet his burden that's required under the applicable bylaws, which I know we've discussed at length and which I referenced in my letter. There's sufficient evidence in the record to deny the application based on the applicable standards and to conclude that his proposed expansions of these pre-existing nonconformities presented in the application, including the intrusions into the setbacks, are substantially more detrimental to the neighborhood than the original nonconforming structure. And I cited a number of cases in my submission that highlight the importance of setbacks. And when you don't comply with setbacks, and when you, for example, as several of the cases address, the result of that is an overcrowding of land, as is the case here, resulting also in inadequacy of light, inadequacy of air. That is a substantial detriment to the neighborhood, because what happens is if you are trying to enforce the bylaws and the setback requirements, and you allow neighbors to intrude upon these setbacks, such as here, and it's pretty, I mean, the roof is raised substantially, that in and of itself is a substantial detriment to the neighborhood, and it's an overcrowding of land, which is very clear in that portion of in the front and rear setbacks where the intrusions occur. And there are a number of intrusions, which are, I won't go through them, but they're identified on Exhibit 2, which I just referenced. If these intrusions are not viewed critically as substantially detrimental impacts to the neighborhood, the zoning rules are essentially rendered meaningless. And I also note that Mr. Stasko could have pursued other alternatives, and I'm not aware that he did. And I'm not aware that these additional intrusions were even necessary to accomplish the purpose that he set out to do. That's not been clear. There's never been a discussion of how he could have avoided further intrusions into the setback to build his addition. There's been no discussion at all. And that really goes to, Mr. Stasko's burden here as well. And finally, and I'm not going to rehash all of the cases because I know you've read my submission and you have it before me, but suffice it to say that those cases support your ability as a board to deny Mr. Stasko's application in light of these substantial intrusions into the setback. Which brings me to my final point. And I can't highlight this enough, which has to do with the issue of precedent setting. Allowing these changes, particularly given the manner in which things have played out here, where it's essentially begging for forgiveness rather than asking for permission, would severely undermine the purpose and intent of the bylaws. It would essentially set a precedent of folks in the neighborhood coming to you all to ask for these additional nonconformities to setbacks without repercussions, and notwithstanding the fact that the overcrowding of land is a serious concern, and that's why the bylaws have specific regulations and rules regarding setbacks, which ultimately leads to deteriorating boundaries and open space in the neighborhood. And I would just say finally that I'm aware of a number of letters that were submitted by neighbors, and I'm not sure if you all saw them, but I do know that those letters also raise concerns of other neighbors aside from the Wyndhams regarding this project. And so I wanted to bring this to your attention too, lest you think that it's only the Wyndhams that have concerns over this property. So for all those reasons, and I'll rely on my submission to you all, setting forth a number of cases that I think support our position that that denial of the special permit application in light of these intrusions is proper here. Thank you.
Okay. Jeff, anything to add? And if it's just that you have a contrary point of view, I'll accept that without a long preamble.
Yeah, it's not going to be long, but I do have a few things. So I didn't receive that submission until about an hour before the deadline for the submission, and so I did not provide the board with a writing, but I did. But I do want to take a few minutes here just to kind of address it. As Jill indicated, the stated focus of the submittal was to outline substantial detriment to the neighborhood. My take on it was that it was basically insisting that her opinion is correct, that it is substantially more detrimental, and that there would be a complete inadequacy of light, air, open space, and that there are substantial intrusions into the setback. That's the synopsis of what I got out of it. But I didn't really see any facts that supported that. Instead, there was a great focus on case law. And I might add, none of the cases construe the Town of Cohasset bylaw. And all of the cases are either factually indistinguishable or legally, I think, miss the mark. And I'm just going to quickly state why. The Harlow case involved building a larger structure closer to the property line than the closest point of the existing non-conforming building. That's not the case here. The Goldhurst case involved converting a carriage house dwelling into a dwelling and then expanding the footprint by putting a completely new second story above that footprint. And the court naturally ruled that constituted an intensification and that therefore a special permit would be required. And in our case, we've applied for a special permit. We've talked about the Bjorklund case. That involved replacing a house on an undersized lot with a house 4 times its size. And in any event, the decision contained language that indicated that small-scale alterations, such as alterations to roof, as a matter of law, do not constitute intensifications in non-conforming structures, such that a special permit would even be required. But nonetheless, we filed for a special permit. The Kennard case involved enlarging a mudroom entrance by bringing it closer to the property line than the closest point of the existing non-conforming structure. That would require a variance, and that's not what we have here. The Blasco case involved changing a non-conforming gravel removal business to another non-conforming business of a demolition landfill in circumstances where the town's bylaw did not even contain a mechanism to change a non-conforming use. That case discussed local controls of uses and minimum tolerance by municipalities. Has nothing to do with Section 8.7. And finally, the Caleri case involved the trial court's upholding of a special permit in the case where 1.5 stories of mass was added in the setback area. We're not adding that type of mass in the setback area. In any event, the issue in that case centered on the burden of proof that the plaintiff has in a de novo trial, not at zoning, in challenging specific conditions of approval. Again, completely inapplicable here. What this application really comes down to under case law, and you guys are all familiar with it, is that the board is charged with determining how and in what manner the house was pre-existing non-conforming. 2, whether the proposed changes within the non-conforming area, and we calculate that as in a stamp plan as 3% of the roof facade, whether that intensifies the pre-existing non-conforming structure. And if it does, then a special permit is required, and you guys are given the discretion to determine whether there's substantial detriment to the neighborhood. So, like I indicated, we produced stamped plans that indicate an increase of 3%. I didn't see that John's plans were stamped, and that was the only point I think that I made about his plans. And I think there's probably a good reason why, because it's not his property, that he can't go on there and do it. So the question is really whether our increase constitutes an intensification, and if so, whether that intensification is substantially more detrimental to the neighborhood. Contrary to speculation, the fact is that the plans demonstrate that there's no further crowding towards the property lines, and that there is no reasonable likelihood of completely preventing light and air, as was alleged. We're not proposing to change the use. We're not proposing to change the occupancy. The post-construction use will be the same, meaning no increase in safety issues such as traffic. And we all know that views are not protected interests in the town of Cohasset. So I think, simply put, the board has all the facts it needs to make the required finding and issue the special permit. And that's pretty much it.
Board, do you have questions of either Attorney Mikesell or DeLisi? Anybody on the board? Anybody in the audience?
I don't have anybody raising hands. I will tell you that we received a letter this evening at 6 o'clock from the neighbors at 480. Tom and Courtney Murphy, I did not distribute it as it was right before the meeting, but I'll make sure it's part of the record. It's a letter just stating that they are concerned about the special permit and are against Mr. Sasko receiving it. So I will place that in the record. But again, it came at 6, so I didn't distribute
Too
it.
late to be considered.
Right, but I'll definitely put it in the record.
All right. Anybody else? Well, we've heard, depends on how you count. We've been hearing this quite a while, since May or a year ago, in January. So I would make a motion to close the hearing.
Looks like Charlie was.
Do I get a second? Matt, what are you saying?
I was going to, but it looks like Charlie was trying to, so I didn't want to.
Charlie, go ahead.
I said second, but
Okay, it's been moved and seconded at any rate. Woody Chidick, aye.
Lee Darst.
Higginson, aye.
Okay, Lee,
David Morris, aye.
Charlie, Dave,
Matt Watkins, aye.
Mike, and Matt. Okay, so it's been moved and seconded to close the hearing tonight. We will, later on, we have another hearing perhaps, and a new hearing perhaps, and then we will go into a deliberation mode. Okay, thanks very much.
Thank you.
Everybody,
Thank you.
both sides have worked very, very hard on this one, and I appreciate the work that went into it, really. Okay, the third hearing, where do we, with Heidi Condon and 45 Sawyer, do we have Jen? Do we have?
Yes, I just promoted Heidi.
Okay, this is a hearing on 45 Sawyer Street to construct a new larger 2-car garage. The plans are submitted. Last time were modified pretty much at the last moment because of a setback issue. Maybe Heidi, you could take us through the plan that we received and if there are any further adjustments.
Sure. I'm Heidi Condon from HC Design. I'm here representing the homeowners, Jen Carpenter, as well as her husband, Michael Boylan. And they've lived at 45 Sawyer Street with their girls. And I just want to walk you through, we're proposing a garage to replace an existing single-family garage or single car garage. We're proposing a 2-car garage. We did make a minor revision at before the last hearing for the 15-foot height limit to the midpoint, and we just adjusted the garage so that if you look at your site plan, on the side setback, the current garage is 3.9 feet from the property line, and the proposed garage is 4.8 feet from the property line on the side. At the rear, we are holding the 6.2 of the garage. So it's currently a detached garage, and we're seeking relief from the
And what about the front?
The front is 87 feet. Because the existing is non-conforming. I can tell you exactly what the current front is. The current front is 87, we're going to 85.
So you're intensifying the nonconformity.
On that side, we're making it less non-conforming on the side, but
Well,
increasing it towards the front.
it's unusual. You are creating a nonconformity. I know it's only 2 feet and it may seem kind of trivial to you, but you know, the bylaw says you have to be set back 100 feet or you don't get, you know, any waivers of this sort.
And we were really just looking at the vernacular of this neighborhood, just in the 2 blocks within the 2 streets, North Main and Sawyer. There are 17 homes that have the same situation. It's a tight knit fabric to this neighborhood, and this is not the only home that has a detached garage that has this situation.
Yeah, but you're intensifying it. You're not
On the
staying
front,
with the footprint. The other homes haven't come before us, frankly, so we haven't
Yeah.
had to deal with somebody else saying, I'm set back, whatever it is, even 90 feet, now I want to go to 85. I mean, you're, to my
That's
estimation,
fine.
you're in variance territory. To my estimation, that's not a big deal to fix either.
It's just so tight. If we make it smaller, we can't fit cars. But one proposal that we'd like to put before the board, if we attach this new garage to the house is currently non-conforming. So we're not increasing the non-conformity. If it's all one structure, then we only have to abide to the 30-foot front setback, not the 100.
Okay, I hear you.
So we're more than willing to attach it so we no longer have a detached accessory dwelling or garage, and it's now one single-family home.
Okay, well, I'd like to ask the board what observations and questions they may have of Heidi. And I think probably the only issue is the small intensification in the front yard, and should she, is she allowed or able to get around this by attaching a garage to the house, in which case it's a common single structure. Mike, you have any points of view on this?
I'm a bit at sea. I looked at the record. I didn't see anything that said when the existing garage was constructed. Do you know when that day was, Heidi?
We don't know. We were thinking the 60s just by looking at the construction of it. You know, it's not old wood. It's not something that was built when the home was built, but it was not built when the bylaws were in place. To our, you know, knowledge, looking at the construction of the building.
And Woody, correct, bylaws came in what, 50, 55, something like that?
55.
Yeah, so we don't know, because we looked through the record as well and felt that it was not.
There isn't an old building permit around?
Not that we found.
Nor, I mean, a question, I don't know, nor any other requests for relief, zoning relief that might have, you know, been from the 60s or something that could be a better estimate of when the house was built. They may not exist. I mean, you know.
Yeah, we
I
did
don't
an
know.
addition, but it was completely conforming to the rear of the home. It did not trigger any special
But
permit.
they didn't have to estimate the age of the house either in the form, the application form.
Oh, Well, the original house is built in the late 1800s, I believe, and it should be on your form, but there wasn't something.
1850 was what was in the record.
And that's what was on the assessor's.
So you're talking about the age, Mike, of the garage itself?
Yeah, yeah.
Okay, sorry, I thought you were
No,
on a questioning of the age of the house. Okay.
No.
we have no record of if there was something there when the house was built.
Yeah.
It's so close to the lot, I'm assuming, and the house to the right is a newer home that maybe it had a barn or carriage house on another lot.
Well, board, go ahead. Questions?
So Woody, I
Comments?
wasn't aware about the 2-foot issue with the front side, or the front setback till now. So the debate on that, I guess, becomes whether the board thinks that that's an extension of an existing nonconformity and we're okay with it versus if it creates something new. I'm just looking at the, so they have an improvement on the side setback, modest, 4.8 to 3.9. But just thinking out loud, if it becomes an attached garage to the existing home, is that actually a worse situation? Because there is still, when you drive in that area, that doesn't, the 2 feet of space there doesn't encroach upon, Sawyer Street, or it doesn't become something that kind of jumps out at us. I just put that out there for discussion.
Yeah, and of course, we don't have a mock-up of what this would look like if the garage, as proposed, were to be attached to the house. But would it, by virtue of being attached, create a greater nonconformity of the house in the rear or side or front, or none of the above? I don't know. I would want to see that, because what you don't want to do is say, gee, it's a way around a front setback for a garage, and find out that the garage rear or something else is exacerbating the house's rear setback.
We are
Invalidate,
currently proposing a pergola, and would the pergola, if it were connected to the house, qualify to make it one dwelling? Because we have that in our elevations, and I can have it connect to the house. And
yeah, I'm interested in setbacks. We haven't seen what the house's setback would look like if you were to attach the garage. I certainly wouldn't want to approve an attachment of an accessory building that would make the house itself more non-conforming.
the house currently is non-conforming to the front of the property. It's 28.9 feet.
Right.
And the porch.
What's its rear setback?
Oh, it's fine.
What do you mean? What is it?
I'm just going to measure it for you. 44.
Okay, it would go from 44 to 4 feet. So you'd be creating a huge nonconformity.
This to the existing 6.2 of the garage.
Okay, so it'd go from 40 feet to 6.2. That's a significant increase in nonconformity.
Yes.
You've got to measure from the most intrusive part of the structure. And if you merge them, that would be, I'm sure, against your best interest. Because then you'd be before us to get a variance in a house.
Yeah, and we don't want to do that.
Probably don't want to go there. I mean, so I guess the question's for the board. I think you ought to, please feel free to ask. I mean, is there a trade-off here of, 11 inches that goes from 3.8 to 4.9 or something? Does that offset a 2-foot intensification way in the back of the property? I mean, I'd have to say, I don't think it's a, a slam dunk. I mean, I think there may be a trade-off, there may not be a trade-off. There may be an issue of precedent. I don't know.
Yeah, I mean, I would think that if we could look, if we end up getting to a spot where we looked at it as an extension of an existing nonconformity, I would think that, you know, not that we're in deliberation, but I would think that an improvement on the side, just taking a look at the property, an improvement on the side is going to be more valuable, you know, than,
Or more compatible with the neighborhood. shall we
yeah, I
say.
mean, I'm not really as concerned, although I'm just kind of hearing the 100-foot setback and kind of seeing it for the first time. But I mean, that driveway is pretty. That driveway and the garage is quite a distance away from the street, and I don't think that 2 feet is going to, you know, be detrimental in any way. But I'm just kind of talking it through to
Well,
make
that's
sure
the purpose.
to make
Yeah,
sure that
that's
we're
what
doing
we're trying to do
the
here.
right thing here. But obviously, they're not going to pass a variance trigger for the garage. But I could reasonably see that, hey, we're squeezing it on we're improving on the side setback, and we're making the front setback modestly worse, but it's overall.
What's more impactful in the neighborhood?
Yeah,
perhaps?
I see it being okay personally, but I don't know what the rest of the board.
Yeah, I don't either. What do you think, Dave?
I'm not sure. I don't have the bylaws in front of me. I need to look at it some more.
Okay. Charlie Higginson, what about you? Wait, let me just say, Dave, if this is in this district, the only comment is a permitted accessory building may be constructed no closer than 6 feet to the sidelines and or rear lines, if less than 15 feet in height and 100 feet in setback. So it violates the, what?
What's the current setback?
Which one? Front?
The front, yeah.
Heidi said 87. Is that correct, Heidi? I don't want to put words in your mouth.
The existing garage is 87 and we're 4.3, 0.7. So we are less than 100 feet. The current garage is less than 100 feet and the proposed is 2 foot 7 inches closer.
So you're not creating a new nonconformity by moving it closer.
It's an existing non-conformity.
Right. So I think we've come up against this question before as to the intensification of a nonconformity versus creating a new nonconformity. And I think, to create a new nonconformity, you'd have to get a variance, which is not going to happen. Looking at an intensification of an existing nonconformity, we've usually dealt with that with special permit deliberation, right?
Yeah, I think there's a question of magnitude. At our just concluded hearing, the Bjorklund case was cited where Stephen Bjorklund expanded something 4 times. The court said, that's too much for you to, get by with an intensification argument. It didn't say mathematically you can go plus 30% and it's okay, and plus 50% is bad. It simply said a 4 times increase is.
Yeah, I think it's kind of still within our special permit discretion.
Right.
On intensification. And I don't really see a 2 foot reduction in the front setback for that garage to be a significant intensification of the nonconformity. If she was 100 feet back and wanted to move it to 98 feet back, that would be a problem.
Because she would have been complying and now isn't.
Right.
Yeah. Yeah, Charlie Higginson, could you unmute, and how do you, what's your point of view in this?
My point of view is a little bit like this is a substantial change. We have no plans of how the garage should be expanded. I think we should suggest that we have a further hearing on this or without prejudice.
Could you be more explicit about that we have no plans, how this garage should be expanded?
Well, you're going to fill up about a 6-foot space between the existing garage and the house. I don't see that exactly how that's going to be, and I hate to approve something without plans of what we're approving.
Heidi, were amended plans, drawings, footprints, site plans submitted to this board?
You should have the pergola on your site plan. And what I was saying is if we were to make it one dwelling, I would just connect the pergola. But I think we decided that was more of an issue and a variance.
I think maybe Charlie's point of view is, what does the house as proposed at the last minute for the last hearing look like in terms of the house and garage? A site plan, things of that sort, elevations. Do we have, Jen, those amended plans?
I think Charlie might be thinking that we should have gotten plans about Heidi's second proposal. The plans that you received secondary at the last hearing are the plans that Heidi's talking about this evening. And then it was more the concern about the front intrusion, and that's what we're discussing. So I think you were asking Charlie what his thoughts were on the existing proposal, not what could come. So I think there's just a little confusion.
Let's find out from Charlie. Is that what you meant, Charlie, or not?
No, I meant if you extend the garage so it becomes part of the house, I do not believe that we have a plan of what that extension would look like.
That's correct.
And I have difficulty in approving something that I can't see.
Well, we're not being asked to approve that, Charlie, yet. Heidi's suggesting that if we were to turn down her proposal, the option might be to move it closer to the house, in fact, attach it. But as I pointed out, that would create another nonconformity.
And I wouldn't move the garage. All I would do is literally move the pergola columns so they touch the house. And you have the pergola design in plan and elevation. Literally, I'd be moving it 5 inches, attaching it to the house.
We've seen this several times now with the pergola creating an attachment so that it's an attached building instead of a accessory building. And I think it's an artifice to avoid the letter of the zoning bylaw. And I don't think that we should be considering that sort of thing. Plus, I agree with Woody that if you do attach it, then you've made the entire house non-conforming, and that's not going to fly.
Yeah, so the issue really is one of trade-off, making one setback a little better, another a little worse. Is that okay, or is that a serious problem? Lee, how about you?
I'm just considering the 11 inches out of the setback where it's in the 6 foot. It would require 6 feet, and I'm balancing that with the 2 feet in the front, I think, just as some others are. I don't have any other questions, so.
We did look at 33 Sawyer Street, who has a garage that's 75 feet from the road. So they are 2 houses down and forward. They did get approval for a project there. It was never put into fruition, and I don't believe they were asking to make it closer. But that was the one we found that's, just 2 homes down. And I did send an aerial view if that helps. I don't know if that's something Jen can share or if you'd like me to. And that was the only thing we provided prior to this hearing, just to look at this, where that 100-foot line is compared to other garages, if it helps the board.
I don't have the ability to share that, but I will say that was an approval. And in that case, they had a 10-foot side setback and held the line at 75 feet. But that was the only example that I could think of, and it was a long time ago, right, Heidi? It was like
It was
2000,
2008, yeah.
2008, and they never built it. But I think that, you know, my humble opinion is I think it is a fair trade-off. So that's just my humble opinion.
I mean, I can share it if anyone wants to see the aerial, if it just helps give perspective.
Well, yeah, I'm really much more interested in this particular piece of property
Okay.
because it's really hard, as you know, to compare one with let's say a 10-foot setback and one with a 3-point-something foot setback. I mean, they're just not the same.
Yeah.
I'm certainly not worried about precedent. I'm more worried about, is this a harmless or almost harmless intensification or in further intrusion on one side and a lessening in another, even if they're not mathematically the same. Might they have the same impact on the neighborhood, impact if any, given the distance? I mean, the other thing I think you've got that argues for your side is that this is way back from the street. It's 84 to 87 feet back. It's not, if it were 10 feet back, I'd have a real different problem.
Sure. And just because of the location of the home, I really can't slide the garage any further into the site because I literally would not be able to use the second garage bay. It's already quite tight to just try to turn into that left bay as it is. And that's why we just felt we couldn't move it any further. It's a 23-foot deep garage, today's standards is closer to 25 or 26. So we felt like we kind of went as shallow as we could to still make it a usable garage for 2 cars.
Well, what is the board's wish? We can, the applicant has, in the person of Heidi, has not given us another option. She doesn't have to, but she hasn't given us another option to contemplate. So we can either take the plan as submitted right before the last hearing, if we've heard the specs on that one, and consider whether that's a satisfactory or an acceptable intensification. Or we can ask for some other plans and rendering if there is an alternative, but I'm not, our job isn't design. Or we could go to the attachment. I personally am opposed to attaching it to the house. I think that doesn't do anything positive.
That seems to be a worse situation.
Yeah. And I'd at that point, that would be much harder to justify in my head, if ever challenged. Really, anyway, and we've had these situations before. We had one up in Church Street ages ago. And it was just simply a way to get around this. I mean, the space had been that far. But at any rate, so how does the board feel? I mean, we can continue to talk about it. We could, if you will, I know we have a draft. We could close the hearing and deliberate on this later, or we could leave the hearing open for more evidence or material. But I'd like, we ought to kind of agree as a board on this one.
Sounds to me like the plan we've got is the best plan there is. So,
Dave, you were cutting in and out, at least on my mic. Would you say it again?
oh, I'm sorry. I said, sounds to me that the plan that we have is the best one that they really can have for this project. So
Okay.
I'm comfortable going forward to deliberate.
All right, Matt,
I would agree.
Charlie Higginson. Charlie, do you agree with them?
I'm thinking.
Okay, all right. No, it's okay.
I did look at one
Lee?
other option if you'd like.
Sorry.
I did look at one other option if you'd like me to describe it. I don't have a drawing. The only other way I could not increase the nonconformity towards the street is if I increase the volume of the building and put my stairs all completely to the left of the building, but then I would need a larger dormer because right now my stairs are at the back of the building. And so why I didn't propose that was then I'm significantly increasing the volume even more. And so I felt the trade-off of increased volume to get the stairs 100% behind the house on the side of the garage rather at the back of the garage and hold that 20'3" depth to that's the current garage was more impactful than this 2'7" increase towards the street, if that makes sense. So I'm trying to I weighed a significant increase in volume seemed worse than and more non-conforming than shifting the building towards the street.
Yeah. Okay, Mike, Dickey.
I would think, my view anyways, I think we have enough to close the hearing and deliberate.
Okay, Charlie, we have you to hear from.
I'll go along with closing the hearing and deliberating. I'm very worried about the extension towards the street.
Yeah, I think we're between, in that regard, a rock and a hard place. We either disapprove the proposal or approve it ultimately. There may be conditions we could put on this, so we'll uncover in our deliberations, but it's either thumbs up or thumbs down on this as opposed to modifying it significantly, at least so far. I haven't heard any solution.
If we get the thumbs down, can I come back with holding that 20'3" depth? And
Well, yeah, I mean, we could always dismiss it without prejudice as our decision. But we would need a, full vote. I mean, it's the hearing. I don't know, Cindy, can we even do that once a hearing is closed?
No, I don't think.
I'm not sure.
No.
Yeah,
No,
we can't do it.
you'd have to come back with a significant, you'd have to do a repetitive petition.
Yeah, then that means going to
If
the
it's a
planning
planning
board,
board.
getting their approval, then coming back to us. That's months in the making.
I think you go on what you have and whether you think you have enough or whether there's some modification that you think would be better, but I don't think you should dismiss and plan to start over.
Yeah. Unless you have a secret plan B on your desk that you just haven't shown us, and then.
no,
All right, I would think that the best thing to do is to consider this as submitted. It's either significantly more detrimental or it's not, and we can deal with it that way, rather than hoping there's some solution that has not yet been shown us.
Yeah, the only solution I have would increase the volume significantly with a large.
I don't like increases like that personally. It kind of makes me, that's a tail wagging the dog. That's not the.
That's why I didn't present
That's
it.
not good zoning.
No, and it didn't make sense from our standpoint either.
Okay, well, I'd like to make a motion, and the board could vote me down, to close this hearing on 45 Sawyer Street. So the motion's been made.
I will second the motion.
Mike Dickey seconded. Woody Chidick, aye.
Lee Darcey.
Lee Darst, aye.
Michael Dickey, aye.
Michael, aye.
Charlie Higginson, aye.
Okay, Charlie, that was an aye, and then, I guess, and then
Yes.
Matt, you're aye as well.
Yep.
Okay, so the hearing's closed and we will deliberate in short order.
Thank you.
Okay, great.
Bye-bye.
We have one new hearing. Oh my gosh, it's a pier, gangway, and dock on 33 Stanton. This seems to be the application du jour, or at least du month. We're getting a lot of these. So John Cavanaro, would you like to open this hearing?
I would.
33 Stanton Road, and give you the floor.
Yes, please. Thank you, Mr. Chairman, members of the board. My name is John Cavanero from Cavanero Consulting in Norwell, Mass, 687 Main Street. And I'm here on behalf of Danielle and Paul Carter, the owners of 33 Stanton Road in Cohasset. And I'm going to pull up a couple of exhibits, if that's okay. I'll share screen.
Sure.
If Jen would enable me to do such.
You should
Thank
be all
you.
set.
So I'm going to start with an aerial view of the neighborhood, just to give you some perspective on what's out here. This is Stanton Road that comes off of South Main Street, just south of Beechwood Street. So the Carter's residence, 33 Stanton, is located right here, sort of near the dog leg of Stanton Road. And it sits in between, there's about 5 docks that are within close proximity to 33 Stanton Road. And what we're proposing to do is to fill in between their adjacent neighbors, a dock that'll be centrally aligned with those 2 nearest docks. So the site plan that you've been presented with looks like this. This is the current site plan. And those adjacent docks that I was referring to, one is on the bottom of the page and the one on the just next to us are the 2 adjacent properties, and then there's a couple more docks to the north of us. So what's being proposed is to site a dock that's generally centered, as I mentioned, between the 2 neighboring docks. It's about 237 feet long to span the salt marsh and wetland vegetation that starts at the lower end of the slope of their lawn and then carries out to the Gulf itself. So the plan is to site the dock long enough so that with a 30-foot ramp and a 12 by 16-foot removable float, that we have adequate berthing beneath the float at low water. So we want to get at least a couple of feet. We like to have 3 feet at low water beneath the float itself. We also try to align the float with the other adjacent floats that are located within the area. And by no means do we want to be more than 25% into the navigable waters. So that's by design regulation. So the pier itself will be made of timber. It'll be primarily without railing for the majority of the length. We try to keep these as low as possible. But when we get to the tidal flat, the ground starts to fall away from us. So we're siting a railing, about 40 feet of railing at the end of the pier before it gets to the removable ramp and float. This has been presented to the Conservation Commission. We went to the commission back in early July, and it was continued until the 29th. Last week. Unfortunately, the commission didn't have a quorum, so we got bumped to next week, which we do expect to close that hearing. The only comment that came up actually was to our benefit. The conservation agent had a question whether or not the salt marsh was actually as far back on the property as we had, our professional wetland scientists had delineated. And in turn, they went back out to the site and determined that the salt marsh actually is a little bit further seaward, and that the edge of wetland that we had delineated was accurate, but they agreed that this was a bordering vegetated wetland line and that the salt marsh line was actually further seaward. So what that actually enables us to do is to lower this first section of pier slightly to minimize its height above the ground. We're dictated in terms of height to maintain a minimum separation to the salt marsh. And that separation is provided in guidance by DEP, but there are other interests that sometimes like to see that elevated even more. So having a little bit less salt marsh to span is a benefit, although we still need to span the wetland. So the principal structure doesn't change dramatically, but that first section may get dropped slightly. So what we'll plan to do is submit the final plan that we have approved from the Conservation Commission, along with the order of conditions to the Board of Appeals, once we hopefully get through next week with the Conservation Commission. And then once that process is closed and this local process is closed, then we have a lengthy process to go through the Commonwealth to secure a Chapter 91 license to have work, permanent work within the high water mark. So with that, this application does fit within conformance of the local guidelines for Cohasset small docks and piers. We don't exceed 200 square feet of on-the-ground footprint. We don't exceed a 20-foot structure in height at the highest point. We're about 15.5 feet at the highest point, and then it gets less vertically separated from the ground as we head landward. Again, the float and ramp come out seasonally, so the pier itself will stay in place. With that, I'm happy to answer any questions.
Okay, from the board's standpoint, how about our dock masters?
John, the heights that you referenced, those are taken from which elevation?
So the highest point is at the highest point between the ground, which is at this point, we're at about elevation minus 1.5 or so. So to get to the top of the platform is at 11, so that's about 12.5 feet, plus another 3 feet of railing is about 15.5 feet is the highest point.
Yeah, because when I was looking at, like the mean high water elevation, I think what you show on here is 3.8.
Yep.
Measured to the top railing, that's 20 feet, but you're saying you're measuring the railing to.
No, that's not 20 feet. So the lowest point of the structure will be where it hits the ground without any water, basically. Okay. So that elevation is about minus 1.5, which is right here at the end. So minus 1.5 up to elevation 11 is 12.5 feet. 11 plus the 1.5 that we're going down. And then if we add 3 feet on top of that, we're at about 15.5 feet. At high water, high tide is actually even higher, but mean high water, say it's at elevation 4, up to the top of the pier at 11 would be 7 feet, plus a 3-foot railing would be 10 feet. At the high water, it's at about elevation 7, and that would be about a 4-foot freeboard from the high tide line to the top of the pier.
Okay. Oh, you know what? I think I think we have 2 different scales on here. I might have been using the bottom scale when I was looking at the.
Oh, you're not the 10?
Yeah, instead of the 10, I think I had the 1 inch being 20.
1 inch equals 20. Okay, yep. So the 1 to 20 is the plan view.
Yep. Okay.
Yeah. And then
Yeah, that just I think everything else looked good to me. I had a question.
No, it's a good question. Yeah, right. No, I'm glad you brought that up because there are 2 different scales.
Okay, so board, other people, questions, comments? Charlie? Charlie's muted.
I don't have any questions.
So there you go. Are you back? Charlie's, no, he's still muted. Let's hear from Lee Darst right now then. Lee, you're not.
I don't have any questions. I reviewed the plans and the application and with John's explanations. I don't have any questions.
Okay, Dave Morris,
No, nothing unusual here.
no, Mike Dickey,
Yeah, I agree. You know, certainly, you know, it's not the only dock in that neighborhood, and that might be Charlie, huh? But I think, you know, frankly, if it hits, you know, if you check all the boxes, then it's pretty standard and straightforward, really.
yeah, that's the way it struck me. Charlie Higginson, any comments, observations? You're muted, so.
Am I still muted?
No, now you're on.
Okay. Sometimes that button works, sometimes it doesn't. All right. Anyway, John, you got 0. Does that mean low water? Because then you have an arrow up above showing mean low water elsewhere.
No, 0 is not mean low water at this location.
What is it?
Mean low water at -2. So this is the datum that's NGVD 88, so that our elevations on the ground match the elevations in the profile. So that's the datum that we're using, and that's why it goes negative to low water.
Fine.
So you
I'm
have
just curious.
two mean
Other-
high water data points or datums that you're using, and then there's also a high tide line, which is a separate concept.
Right. Yeah, and
But
there's
the
Otherwise,
difference
I
between
agree.
those two is only 0.2 feet, so not much.
Otherwise, I agree. This is similar to the other docs that we've approved, and
Yeah.
I see no reason for objections.
Okay. Yeah, Jen Orm, is there anybody in the audience who'd like to speak for or against this, or questions?
I'm looking right now. No, I don't see any questions and no hands raised.
No, I think at this point, given that this is fairly routine, I would move that we continue the hearing until next month, primarily for the purpose of deliberation and any last substitute submissions.
I'll second that.
Okay, moved and seconded to continue this until September, what the hell, 7th. All in favor, Woody Chidick, aye?
Lee
Michael
Darcy,
Higginson, aye.
Okay,
Dave McMorris, aye.
Matt Watkins, aye.
okay, unanimously moved and
Thank you very much. I appreciate it.
continue this until September 7th. And before we close tonight, we'll assign somebody to do a draft. So we have two deliberations left. We have the one for 488 Joseph Road, which I've drafted, and one that Mike Dickey has drafted for the 45 Sawyer Street. So let's take them in order. We'll take the 488 Jerusalem Road decision, and I would like to start entertaining a discussion on this. It's long, I know. There are a lot of findings. I thought it was important to go through the various findings, starting with the first request, which was to bundle all the activities under one special permit request, including those that had previously been approved by this board. And there are a couple of major ones and there are a couple of minor ones, but the other major issue has to do with is the front setback 18.2 feet or 21.4 feet. We've heard a lot of testimony in all these. And if you want, I'll take you through each of my findings quickly. That I think it would be serve no purpose to merge all activities permitted and not yet permitted and unpermitted and whatever under one application. Complicated enough as it is, and those that were permitted and some minor field modifications that Bob Egan had made when he was building inspector seem fine enough. We still have plenty on our plate to approve or disapprove. That's new. Secondly, an important point, because height figures large in this submission and argument against, has to do with pre-construction grade. And I know there was a survey done in 2009, but I saw nothing in the submissions that would tell us that the 2017 calculation of pre-construction grade was flawed in any way. It served the it was accepted by this board in 2018 as the basis for height and other dimensional calculations, and I didn't see anything that said that was invalid. A concern was raised that, yeah, but the pre-construction grade has been altered. Well, pre-construction grade is just about always altered when you start construction. So, which is why we asked for pre-construction grade. So I'm not surprised nor very focused on what's been altered since then. There was a request or a suggestion that there was an illegal cement slab in the corner, southeast corner of the building. And that probably invalidated the entire application. I say, no, let's take it piece by piece by piece. And, so on and so forth. So I'm not too concerned about revisiting that issue. We certainly had previously found that the property has 2 front yards, Linden Road and Drive and Jerusalem Road, 1 rear yard opposite Jerusalem Road, and a side yard opposite Linden Drive. And I think that finding absolutely stands. It's the way we've viewed things for at least the last 10 to 15 years. We all agreed that the front setback on Linden Drive, which has been really the biggest issue, should be measured from the periphery of the Merrill's porch. That just having a porch doesn't disqualify that porch as being part of a building. A building has a roof. This porch has a roof. And if you take the literal wording of our bylaw, I think there's only one conclusion to draw, and that is the Wyndham's porch, they are the nearest neighbor, is part of the building. Hence, the implication, a derivative of that assumption, is finding 5 that the front setback on Linden Drive of the Stasco dwelling is 18.2 feet. I don't think there's any other way. Sorry, Mike, did you have a question? No, Mike, did I see you raise your hand?
No.
Okay, no, I didn't want to talk over you if you have. There is another issue that we can certainly talk to and chew over, and that is the substantially more detrimental issue. I think I wouldn't hang too much a neighborhood, although we've heard from a couple of, and a butter of the Wyndhams, and one other person in the area, but whether the neighborhood is large or small, we haven't heard from too many neighbors that would qualify as abutters or abutters of abutters. But substantially more detrimental is a well-established principle, emphasis on substantially and more detrimental. I think the Wyndham side has made a very good, strong case that there have been a lot of changes. But just because something changes, in my estimation, doesn't make it worse. It simply makes it different. And when you get beyond some minor changes into matters of magnitude, yeah, I think then you can sort of entertain or consider substantially more detrimental to the neighborhood. But in most cases, the changes that we've been presented with because of the 18.2 foot setback have been relatively minor, if not absolutely minor. And I also found, and I think Jeff DeLisi might have referenced this point, that claims about light and air and claustrophobia and things, have always been required by the board to be substantiated with facts. How much of light and air will be prevented from shining, and will that cast a shadow, for example, over a house for much of a day, so on and so forth. We didn't get any of that. All we got was the argument that this is different, it's going to be worse, and but I didn't see the evidence to say how much worse, and I would suggest evidence by trained professionals that could substantiate that claim. I could make a lot of claims personally about things, but I'm not qualified. I think the seventh finding, the plans are a little ambiguous here, and I think one of my outs is listed here, but the stairs, the steps, and unenclosed entry porches are permitted projections. They're by right. They don't require relief as far as I could see from the plans as submitted. And one caveat that we can deal with later when we talk about decisions is, if the plans were not entirely accurate, then the building inspector would have to step in and bring that issue back to us. But per the plan submitted, I thought these were all qualified as permitted projections. The rear roof, this 3% or 2.7%, I saw that in the latest submission, 2.7% volumetric increase. That doesn't pass the substantially more detrimental test in my estimation. It's minor, and which leaves you with basically 97% or more of the volume outside the rear setback. Yes, it's taller. I agree. But it's also by right. And the by right issue, I think, as we think about the various issues raised, is really important, because many of these matters are by right. They've either been previously permitted, in the case of the front porches, minor field modifications approved, which I don't think present any detriment, or are really beyond our control, our authority. We did have a couple of letters that I got just before the hearing that Jen Orm sent on. They were submitted in June 1st, but a lot of these have to do with the appearance and massing of the building. And I won't argue that the building is larger and more massive, and whether you like the design or not is in the eye of the beholder. But be that as it may, many of these issues are outside of our purview, including an issue raised about the use of the public property, the street on Linden Drive, as access to the garage and stairs and things. I think that's a matter of the landowner, in this case, the select board, to deal with. But I don't think we can go giving opinions or dictating how town property should be used. There are some nonconformities. No question that cement slab was never approved. And I think that does need a decision from this board. The shed roof, which they've proposed, does need relief, but they also agreed in their last hearing to pull that back and not make that a subject of the special permit hearing, so we don't have to rule on it. If they want to put a shed roof in, they'll have to have a new hearing and come before us. And the other issue that concerns me is, frankly, that there has been a sort of a creeping set of changes in these plans that you really have to look at with almost literally a microscope or a magnifying glass, I should say, to catch. And one of those changes was an increase in interior roof height on the rear half of the building, which puts it just about, a finger's breadth away from being a habitable space. It was never presented as a habitable space at all. And I think if they had, we might have had another issue. So we come down to various and sundry decisions in my page 8 or 9, but basically what I'm saying is that what's done is done, and we can confirm prior approvals, but I don't think we have to revisit them. I don't think there were any errors of law in anything up to now. We have 2 unauthorized additions, a portion of the main roof within the setback and a porch extension. And the porch extension, by the way, is kind of a sliver of its exterior. About 80% of the porch is pre-existing. And almost all of that porch is also conforming. I mean, or is outside of the setback, I should say. So the proposed enclosed addition at 15%, perhaps 20%, to my mind, didn't, again, violate the not substantially more detrimental principle. It seemed to me pretty minor. And the main roof that falls into the rear half of the house is probably 3% or less within the setback. Again, very minor. I don't think it affects the windows in any material way in terms of light or view, none of which are protected anyway in this event. But so I would propose granting a special permit for those 2 additions. But the other 3, I would propose that we deny the shed roof, which they've pulled, I think, but that's not formally pulled. So it's part of the decision and or a request, and I think we have to act on it. I'd deny it. I'd deny the rear cement slab, and I'd also suggest that we put some language around that so that that rear slab is not enhanced or used in a way that would be really visible or intrusive into the rear yard. It's a nonconformity, as we know, but it doesn't create a new nonconformity. The garage is that. So I would suggest that we, ban any awnings, machinery like generators or HVAC equipment. And the third is the attic height, leave it as submitted originally to us and leave it as submitted 1.5 years ago at 6.5 feet. That renders it very usable, in my estimation, as an attic. It does not render it habitable as a 3rd living floor or 3rd floor living quarters. So now, have at me. I know that's a monologue, but I thought I would, you've all read it, but still. Somebody like to dispute or just say it's not clear or you've gone too far or whatever. Please.
I can say something positive.
I can take some criticism.
Woody, I thought it was well laid out, well reasoned. I agree with your conclusions. One thing that did strike me during the Wyndham's attorney's presentation was her contention that it's more begging for forgiveness than asking for permission. And I think, as it turns out, there's very little here that requires begging for permission or begging for forgiveness. But when this whole process started and everyone was under the assumption that the setback was 20-some feet, there was an awful substantial amount of building that occurred without permits that would have been non-conforming given that setback. And I think that the applicant was very fortunate that the Note 3 revised setback turned up during the course of this application, or I would be advocating for some demolition to be occurring.
I would be right with you. And up until a couple of months ago, I thought that's where we were headed.
So I just wanted to note that because I mean, as the application developed, things changed, fortunately for the applicant. But the way this project was done is totally unacceptable and never should have occurred this way.
Yeah, and you know, one of my proposed conditions, at any rate, is number 6, which is 2 sets of as-built plans. Okay, prior to occupancy permit. That's the boilerplate part. But any changes to plans as of our hearing in July on 13th, including minor field changes, shall be submitted to this board. I'm not trying to cast aspersions on the building inspector's acumen. Far from it. I mean, he's been very sharp and aware of changes, but I want those to come to us and not have creeping changes become oh, well, it was approved in a verbal conversation, blah, 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 6 months ago. I mean, none of that. The plans as of the 13th of July are frozen in time in my estimation, and anything, if it's minor, we'll have no problem opining on that and approving it. But I don't want to put the burden on the building inspector. I think we're going to have to hold the line here. And Dave is right. If it hadn't been for this fortuitous note 3 application, the applicant had gone ahead and built within an apparent setback. It wasn't that he was just building. He knew where the setback was, and his team knew where the setback was, and they went ahead and built in it. It's the setback that moved to his benefit. And it's not part of the decision, but it does, I think, require us to have really sharp eyes in this as we go through. You know, I mean, I don't know how the others of you felt, but I certainly was heading down the path of the teardown because it would have been massive or significant. But
Yeah, no, 100%.
it isn't. I mean, I buy the 18.2 feet. I mean, I think the application of note 3 is spot on.
Yeah, no, I agree with that 100%. I think Dave said it well. I won't kind of repeat it, but that's kind of what, as this evolved, that was my take as well. And I think, it's a lengthy decision that you had to pull together, Woody. I thought it was well done. And I don't have any comment. The only comment that at some point we might want to massage into one of these, just so that it's clear. Obviously, if we vote to, I think in being okay with the rear roof height, just somewhere within the decision to just reference that both heights, neither of the 2 heights exceed 35 feet. In other words, we're not conceding, something above and beyond with that concession, if you will, or with that approval, if you will,
Yeah. Now, Matt, when you say neither of the 2 heights, are you talking about the height outside the setback and the height within the setback, or the front half versus the back half?
It was more so, it was I think just the overall height.
Okay.
Of the roof, because there was the potential to modify the overall height if we hadn't approved the additional
to make it flat
footage and make it flat. But, I just don't want it to look like, because the option B might have protruded on their privacy, option A was chosen, and it creates something that's bigger than a lot, than.
Yeah, I can put that in there. Of course, if the plan as submitted says 35 feet and it's 36, that violated the plan itself was incorrect, and whoever signed off on it signed a false, false submission. But I'm happy to put it in. I would hope it would go without saying, but isn't going to hurt, to my estimation.
Yeah, minor thing. And then when I heard when you described this, the concrete slab, and I liked how you had in there that, walls and or roof over this slab will not be allowed, including semi-permanent covering such as mechanical or hand-operated awnings. But I noticed when you described it too, you mentioned generators and some other things.
Well, I threw that in, and the other two things that typically, and we've actually had cases on this, one of which was in Pleasant Street, both HVAC generators or whatever you call it, air, and also generators when the power goes out. I mean, you could have a 6 foot long, 4 foot tall electrical generator that would look like hell. I think it would defeat the purpose of you've got a very low, almost invisible cement slab and leave it like that, and don't clutter it up, or don't make the neighbors look at whirring machinery. I mean, the stuff does, add a noise factor that I think you might at that point have a case. So I may also add in with you guys' approval, any sort of HVAC equipment as well. I such as not, in other words, as Cindy or somebody said earlier tonight on the other hearing, it's not limited to, but including or inclusive of. So these are examples as opposed to a laundry list that, laundry list.
And maybe you meant to, or maybe you want to put, like when you say such as mechanical, maybe equipment is a word that's, we have such
or don't like.
Well, it would be good. I just don't want to see because right now the way it reads is including semi-permanent covering such as mechanical or hand-operated awnings.
Yeah, I changed that a little bit today, such as awnings, semi-permanent coverings such as awnings, as well as machinery such as generators.
Oh, okay. All right, great.
But I think maybe just throwing in, I don't know if HVAC, who is more expert than I am? HVAC is machinery. I did use the phrase such as, but yes,
Okay.
Go ahead.
Woody, I like what you said earlier, giving the examples and putting in the phraseology we talked about before, including but not limited to such things as HVAC, machinery, so that it's clear that you don't have to exhaust the limits of your.
Yeah, because whenever we try to have an exhaustive list, we're going to miss 5 of them, whatever it is. Yeah, and I think everybody would then understand with those examples, but we've dealt with coverings, awnings, and I think we've dealt with machinery that, goes chug in the night. And, I suppose they could put a chair out there. I don't want to get into that, but I don't want stuff that the neighbors are going to be looking at as intrusive or inappropriate. Let me put it that way, inappropriate for
Great.
what I can see from my front living room.
That sounds
Okay,
good.
yeah, no,
And I think under 6.
Change if everybody else agrees. How about other stuff? I mean, this wasn't. There wasn't much.
I think under number 6,
What?
just a small thing with some of the other letters we got. I think you're just going to edit the second sentence of finding number 6 to just.
Oh, yeah, because those
limited
3,
just
when I
to-
wrote this, I hadn't seen those, so
Yeah.
I'll add the 3.
Yep. But no, I know it was just looking at it, it was a long one to write. So I think it looks good. I'm in agreement with it. So I don't know what the other thoughts are.
Yeah, how about from other people?
I agree, Woody, with what everybody said. I don't have anything to add to it because everything that I would have added has been covered already. So I think that you put a lot of time and effort, and I think that you made clear every single point and supported each point with testimony or written materials.
Yeah, and when I wrote it, I thought to myself, all right, so let's say I'm on the other side, and how would I argue against myself? And that's not impossible, I mean, by any stretch of the imagination, but I kept saying, I couldn't prove substantially more detrimental by most standards. You know, I couldn't prove the economic harm or the impact, any special impact it was having on me. I couldn't prove malfeasance. I couldn't prove, changing plans or even the building of that foolish cement slab. I mean, when that went in, I think that the majority point of view thought that was a rear yard and not a side yard. No, the other way around. Thought it was a side yard, not a rear yard, or whatever the hell it was. But anyway, so it wasn't intentional. But as the goalpost changed, so too did the findings or the requirements either for or against a special permit. So I wouldn't want to be arguing against myself. I'm against this decision. I think that's my takeaway. Could be done, but I wouldn't be able to do it. Mike, what about you?
This has been very complex, and I think also seems to have a long kind of history, gone through different stages. I gotta say, I fully understand why the Wyndhams are so PO'd. I would, if I was in their shoes, I would be PO'd too, because from what, again, I'm new to the board, so I haven't been fully part of this drill, but what started out as just some minor renos back, a couple of years ago have become a complete gut job, and the massing of the place looks to have doubled or tripled in size. I'd be just so choked if I was the Wyndhams. So, I think you have written a pretty good opinion, Woody. Which isn't to say that the Wyndhams might not try and challenge it anyway, I think it fundamentally sound and logical, and frankly, I'm a little shocked, because I thought for sure that I can't believe Ryan might get away with it, frankly.
There's no question the massing is immense, and I won't get into design because we're not a design board, but I agree. If I were a neighbor, I'd be very upset. And this house, when it first came before us back in 2017, was in my estimation, a lovely, unintrusive part of that neighborhood. But the bylaws are the bylaws, and you know what I mean? Our job is not to be creative here in terms of what we like and don't like. I don't blame them. I don't blame the neighbors for being concerned or upset. But maybe in time, the bylaws need to be altered to prevent situations like this, or put a constraint on them. But that's possible in the future, but it's not the present.
Yeah, I also say I have some sympathy for their argument that again, perhaps it's just happenstance, but the notion that Ryan kind of took a little bit here, a little bit there, and kind of all of a sudden, but by kind of hiding the pea under the walnut shell a bit and shifting things around, he was able to achieve and end up in an end spot that perhaps he might not have been able to get to if he had come with a complete coherent package right at the outset. Do you know what I mean?
I do. Yeah. And I thought about how we could have either insisted on that or prevented what happened, and I don't have a clear path there. I just don't know. I'm not willing to say I don't know. I just don't know. Dave, what about you on this decision?
Well, we don't have the authority to shut down the work unless there's some application in front of us. And we had, the building inspector was doing his job and issuing building permits on things. And we're kind of looking at them all in retrospect. I think that, the application of note 3 here is of great benefit to the applicant, because the way, like I said before, the way the project was done was the wrong way to do things. And if the setback was what we originally thought it was, I would be strongly supporting demolishing what was built there. But as you said, the bylaws are the bylaws. And we have a certain amount of discretion, particularly in the special permit area, but we don't have any discretion if the bylaw says that something is to be built of is right. And most of this project was built as of right. And the areas where we do have discretion, I thought your decision exercised our discretion properly all the way through. So I'm in full support of what you wrote.
Charlie, you have a point of view before we bring this to a close?
Does that unmute me?
Yep, now you're okay.
Okay. I totally agree. It's a very good decision. I have a couple of quibbles. Number 9 on page 7 and 8.
Okay.
The new enclosed porch represents 15% increase, which can barely be seen by the abutters at 488 and 482 Jerusalem Road, and therefore is not substantially more detrimental.
Oh, wait a minute.
I'd like to scratch that therefore, because more substantially detrimental is not determined whether they can be seen by 88 and 82.
Okay, and also let me cross out 488 because that's Ryan Stasko. It can barely be seen by the Wyndhams, and there's one other person who submitted a.
Yeah, but just leave
I had the wrong. Geez, I'm glad you brought that up though, because I misstated it. But no, I know the basic point you're making. Cindy, do you have any issue with just crossing out will not be substantially more detrimental? On this 9, the last sentence.
The last line, just scratch the therefore.
But just scratch the therefore. I see. Yeah. Okay, I'll make that change.
And I have a question on 5C.
Got it. Wait a sec. 5C. Are you talking about the final decision?
8A, yeah.
Yeah. Proposed increase in attic height?
Yeah. As I picture it, the roof is a certain height, then there must be stagnant space, and then a ceiling that's 5'5"?
6'5".
6'5"?
To the ridge, yep.
So why don't we say specific? Because I'm afraid he'll just take that ceiling out and just go to the roof. That's
isn't that then increasing the attic height?
What?
That's then increasing the attic height above 6'5".
Is removing a ceiling increasing the height? I would like to say you can't change the ceiling more than 6'5".
Oh, I see. I hadn't thought of that distinction. The ceiling height. Maybe what if I cross
any increase of as little as 1 inch above the ceiling height of 6'5" will require approval.
Yeah. Okay, above 5 feet. Yeah.
Then there's no wiggle room.
Okay.
That's it.
All right. Ceiling height is, yes, it's ceiling height that we're concerned about because it's the ceiling that makes it habitable or not. And then all of a sudden it's 7 feet 1 and 7 feet 2 and nobody's ever going to see it, or it's a little tiny. If you look at the plans as submitted, where when it shifted back in, I think around February and April, two different sets of plans. I mean, it was hard to spot. That just a little tiny notation. No mention that it's a change. There were other changes as mentioned, but this was just, a little digit. So, okay, I mean, how do people feel about substituting ceiling for attic and going with Charlie's modified wording there? That we just don't want the ceiling to be greater than 6'5". It could have, well, he also is obligated to stay with the roof ridge line at 35 feet. So I think that's covered.
Oh, yes.
Yeah, that's covered, or will be. Yeah, no, we will mention that as well. I think Dave suggested the 35 feet. You're suggesting ceiling, and that should cover it. And whatever happens between 35 feet and a ceiling of 6.5 is probably empty space, but he can do with it what he will, except make it habitable. Okay, other people? I like your thoughts. All right. Do I have, I'm not going to make my own motion.
This one we have the three voting.
Yeah, the three musketeers here. So Dave or Charlie, would you make a motion on this one?
I move that we approve the decision as amended.
Yeah.
Second.
Okay. And Dave, did I hear you second it?
You did.
All right. All in favor?
David,
Woody Chidick, aye.
Lee Darst, aye.
Okay, sure. Everybody's welcome. Absolutely in this one. Okay, so I will make these amendments. If you spot between now and whenever, tomorrow or the next day, any typos, let me know. But I think this is a good one. So we have one last, and it probably should be a pretty quick deliberation, which is 45 Sawyer Street. So it's the plans. I think we kind of agreed that it was the plans as submitted just before the last hearing. And the issue is one of trading off an improvement in the side setback with a kind of a detrimental change to the front setback of 2 feet. But the front setback on this attached garage is pretty far from the street, and it is a crowded neighborhood. So if it's 80 some odd feet back from the street, it's back by more than most of the garages in the neighborhood anyway.
I see. Charlie Higginson, a comment. Why isn't the move of the garage so it's closer to the street a variance rather than a special permit for enlarged, expanded nonconformity?
I think because it's an existing nonconformity. In other words, David had said, like if it was 101 feet now, and they were making it 98, then it would be.
You could make it longer. It'd be an existing nonconformity, but if you make it so it's closer to the street, to me, that's a variance.
Well, he's saying, but Dave's argument was this is an extension of a nonconformity, an existing nonconformity. It was already non-conforming, pre-existing at 87 feet. And if it went to 84 and change, the house is, I don't know, the house is still the 30 feet back from the street.
The house is okay. I just have.
Yeah.
We have never thought an extension reducing the side setback was an extension rather than a variance. And I just don't see the difference.
Dave, you want to chime in?
Yeah, that's a good analogy. If someone comes in with an application and they're, instead of 15 feet from the sideline, they're 12, and they want to be 10, do we consider that variance or do we consider that special permit?
Because they're already non-conforming.
Mm-hmm.
Cindy, you're muted.
I think if it's already a previously existing non-conforming use and you are changing that, then you're altering that pre-existing non-conformity. And if it was already, if it was conforming 100% and you wanted to do something now that would not be conform, you would be seeking a variance. I think it is the pre-existing non-conformity that means it's an alteration of that as opposed to a variance. That's how
Which supports Dave's.
I agree with David's position on this.
Now, Charlie, it seems to me that if they had moved this forward from 87 feet to 20 feet or something, then it would be most likely substantially more detrimental. I mean, it would be so much of a change in the nonconformity that we would kick it out. But in this case, it's, yeah, I mean, I think the combination of trade-off and minor, I don't think that carries the day, but you know, it's a couple of feet and it has existed already. I don't know, to my mind, there's no harm here. But I mean, the point that Charlie made, I mean, you know, you're making it worse. I think there's a question of magnitude as well. I think that's what the Bjorklund case and a couple of others pointed out. You know, when you extend increase the nonconformity by 4 times, you're in a whole different ballpark than increasing it by 5% or 3%.
So if I wanted to raise my 36-foot roof to 40 feet, that would also be an extension of a nonconformity?
You would be, were you already non-conforming in height?
Yeah, that was the way I stated my question.
Because a garage, you would be over the 15-foot thing, and now you're going way the hell up. And you would argue, I would argue that the magnitude increase is substantially more detrimental to the neighborhood.
Yeah, that's how you get out of that, right? You'd argue that it would be not substantially more detrimental. So, whereas moving a roof height from 36 to even 38 might be, you could argue it would be substantially more detrimental.
Yeah, I think we've taken certainly a strong line on roof, a strong position on roof height in general. Yeah, and yeah,
I agree. This is the best solution, but I'm worried about we're opening up a Pandora's box.
I think we're going to have to apply the substantially more detrimental to the neighborhood and the issue of magnitude. I mean, you know, we have no particular bylaw that deals with volumetric increases in the setback, but we have allowed them. We allowed one on the beginning of Black Horse Lane a few years ago because it was 30 or 40% increase in facade, and you know, so that was the same kind of principle. If it had been 150%, and we've done that one too, no, you know, there isn't a bright line there. But go ahead, Cindy.
I don't mean to interrupt, but I think it's the nature of the beast you're dealing with. these, I don't think you have to unnecessarily be overly worried about precedent setting, because I think every single one, which is why it's a special permit request, has to be evaluated based on the circumstances of each particular application. And here you have, in one place, it's a little less non-conforming, in another, it's a little more non-conforming. Overall, is this substantially more detrimental? And I don't think you can right line. I think it's every case you have to look at.
Well, I think also, Cindy, what you're kind of leading toward is that we should take this as a unified whole. You're gaining something here and you're losing something there, and is the net impact of these two changes substantially more detrimental or not? Then I think you could get closer to the answer of no. If you're going to take it piece by piece by piece, well, maybe not, but I think in this case it's.
I think in this case, you're asked to look at the package as a whole of what they want to do.
Yeah.
I don't think picking it apart does anyone any good, because you can't really come out with a situation where, yes, we'll let you move it here, we won't let you do it there, and we're not sure about this, because then you're not granting or denying a permit to allow what they want to construct.
Yeah.
In my opinion, I think you have to look at the plan that's before you and the impacts.
And take it as a whole.
That's my opinion, yeah.
Yeah, no, I mean, I'm following you. That you know, if all they wanted to do was one thing or another, if all they wanted to do was move it forward, I don't know, maybe it's still, you know, minor and not detrimental, but I think because of the trade-off feature here and the fact that it's set way the hell back, I do not see this as substantially more detrimental. But if they had wanted to make more than a couple of feet change to an existing nonconformity, that might, well, it's more than a couple, but if they wanted to go 20 feet more, I'd have a problem, real problem. But I don't have to deal with the 20 feet more. That's not before us, you know. They might not. Yeah. They may not get the same result had it been substantially different. So anyway, yeah, I like Mike's decision, and I think we can just make that notation and a little correction about the 80 feet versus 100 feet. But
yeah, I hadn't picked that up from the prior meeting, so I need to redraft that decision.
Yeah, but that's just a little wording change. Yeah, you just have to put another number in there.
Should I not? But should I not add something about, you know, we don't feel that the you know, as you're saying, that it's substantially not more detrimental. It's not substantially detrimental.
Yeah, I think that's in your decision, where you have to say that it's not substantially more detrimental.
Yeah, okay.
What you want to change is the part at the top of page 2 or whatever, where you talk about I can't find it now, but 80 feet, you know, because it's you know, just change the 80 to 100. Yeah, no. Basically, and then toward the end, it's not substantially. The proposed changes. Yeah. I think taken as a whole, you don't have to say taken as a whole, but
because that's I mean, that's what I see as the real issue here is, you know, I think the argument would be that, you know, given how tight that neighborhood is and the existing garage, you know, they're actually doing something that I think probably works pretty well, but it you know, and most of the new structure is on the, you know, to the west as opposed to the east, where they're tied up against the boundary. But
so it's going away from the setback.
Sure, but I think they are adding to they are adding mass within the setback though, right?
Yeah. Yeah. It's not the majority of the mass that they're adding, but it's a piece of it, certainly. Yeah. But again, you know, so they're adding 25 feet long by 11 inches wide. I mean, you know, so. Yeah. Anyway, I'm comfortable with the with where we're coming out, Charlie, you raised an excellent point, but I think the decision should grant them the relief they're seeking.
Okay, well, I will
But wait, we have to vote first. But
redraft and recirculate then.
And Mike,
Yeah.
I'm guessing that number is right that you got from what was submitted. I didn't run calculations, but it looked a bit high when we said that volume increase goes from like 3,100 to 10,300.
I will confess to not having had sufficient engineering training in law school to be confident that I read
God's
this
sakes.
correctly. But I did my best to did my best to get numbers off of the site plan and the other materials that they.
But I don't think that's right. Do you, Matt?
I mean, I'm not the expert either, but it just looked a little bit high if we're saying that all of that is within the, non-conforming volume piece, right? It seems to be a lot within the.
Well, a lot of it's non-conforming, goodness knows, but I can't see an increase from 3,000 to 10,000, a threefold increase in non-conformity.
Well, I got that off of the materials that were submitted.
You may be correct. I didn't check the. I don't know. I've got it
Look,
before, but
as I say, I'm not going to confess to having any formal engineering training.
okay. One thing we could do is approve this decision as written, subject to a confirmation or recalculation, if you will, of the volume that is in the setback area, the volume, and the volume that is proposed to be in the setback area. So that would take some front setback as well as some, as a plus, and some negative, some minuses on the side setback. I think, but I'm not positive.
Yeah.
Because the garage is being widened. And it may, Mike, I'm surprised. This would threefold increase in
They're
non-conformity.
They're adding a second story as well. So the cubic foot, the volume, remember that it's not square feet, it's cubic feet.
Yeah.
And that creates, because they're adding that second story, and I think a dormer as well, that number goes up pretty quickly.
Does that change our point of view?
Not mine.
I'm comfortable with it. I just.
Yeah, I know it was right here in your decision as well on page 3. I don't know. I mean, it's close the hearing.
Cindy has a comment.
I was just gonna say, is there any way Jen could check the math with the applicants? The person who actually did the drawings and submitted the information, and just either confirm that this number is accurate or give us what they think the real number is?
You could, if you want to vote it and have me confirm everything and put in either.
I mean, we have done that before. We could, it's not really new information. It's a confirmation.
I mean, we're gonna end up, if we're steering towards approving the decision, it's gonna be as amended anyways, because we had, some updates that have to be made to it, and it's.
Yeah.
I think if it's just a verification of the numbers, but I don't think we're in a spot where, hey, if the numbers come back and they confirm that they are what were presented, that we would be redeliberating on it or anything. But we're just going to make a motion, I think, to accept the decision as amended, right?
Yeah, I would, but yes, as amended and as the calculations of volumetric calculations in 3, page 3A are confirmed. I mean, it's possible. I mean, Heidi's no engineer either. I don't know, I don't want to do mental math here. I can see what Mike's point is about going up, and you've got 1.5 feet of side setback times 22 feet or whatever the garage is now, but and you go up 2 stories, you've got but I'm not sure I see a cubic increase.
Well, maybe I'm wrong.
No, I think you're reporting what was submitted. I'm not sure what was submitted is exactly accurate.
Well, okay, but I again, I'll once again say I'm kind of new to this game, so I may be missing something, but I thought what was happening was that, there's the side setback issue, but also a side 20 foot from the side of the lot. And so there's a piece of the existing garage, not only is, not the proper distance from the side, from the east.
It isn't the 6 foot setback. It's the side yard setback for a dwelling or a structure.
Yeah, and so what's most of that existing garage is already within that 20-foot setback, and they're expanding the area within that. They're building in that 20-foot side setback and so that's where all that non-conform increase in cubic feet is coming from. It's not that the east. The east facade is increasing by X square feet because it's a little longer and a little higher.
I wonder if when we asked them to bring down the height, though, if that changed. Remember
Yeah, it was 22 or 3 feet, and they brought it down to 15.
And when it comes down to 15, I guess just thinking out loud, right? What does?
Yeah, and a pergola,
does that count?
as she's drawn, it doesn't add much volume. It's mostly an open structure.
What's the next page, Jen? I don't know who's on the screen. See, that they're saying the whole existing garage is in the setback, the side setback of 20 feet. And
But it can't be, because the existing garage, it looks like, is 25 feet wide. That's proposed. Sorry,
yeah,
proposed. Existing garage facade. Okay, so it's 23 feet, 3 feet of which is conforming, right? The western 3 feet is conforming.
Doesn't it say the setback? It's 488. It's showing the cube. It says the existing garage facade setback is 488. And then but I think that looks like the new garage.
well, yeah. I'm confused. No question.
It says proposed 2-story garage volume and setback is 9,265 cubic feet. Right here on this page, right here.
Okay, so let's just take that at face value for the moment. What is the existing garage in?
The existing 1-story garage setback is 3,105.
So the increase goes from 3,000. Now going down to the next page because I wasn't memorizing. 3,000 to 9,000. Okay, it's not too far different from the 10,003.
Okay.
I wonder if she's.
It just seems high to me, but.
Yeah, and I think I remember now, anything that's set back from the line, present or proposed, anything that's set back more than 20 feet to the side is conforming.
Wouldn't she subtract? I think I should ask her to double check the calculations.
Yeah, and
please do.
and the volume.
Because over here,
rear setback issue, which is again, is it 30 feet in this district?
Yes. Yep. It is
30 feet and
15, I think, on the.
Some of it is any of that conforming? It's a little hard to say. It's this shows 23 plus 6, 29. Yeah, most of it is probably the existing.
Yeah, this existing, so I think if you add up these three,
See, I
Percent.
think a lot of the yeah, okay. Anyway, I think the calculations probably aren't quite as dire as they appear to be. Because there are some conformities in the existing structure. But
right,
not
you should
many.
count it from the 4 point over, whatever the 4 point feet over
Yeah.
to this. And
Well,
you
anyway,
know,
why don't you get her, see if she
I'll
can
get it. Yeah.
get her CAD cam or something to fix this. I would make a motion, however, to approve this with the, under the condition that the calculations of volume within the setback be confirmed. By-
And the addition of some not substantially more detrimental language as well.
Right, right.
To
That
address-
taken as a whole,
Yeah.
the proposed changes are not substantially more detrimental to the neighborhood.
Yeah, I would second that.
Okay, moved and seconded. Woody Chidick, aye?
Lee Darcey.
Dave McMorris, aye.
Michael Dickey, aye.
Matt Watkins, aye.
Charlie Higginson, aye.
Okay, unanimous. Very good.
And I just have minutes that I did for last month, which was July 13th.
I will move to approve the minutes as submitted.
I just had one small correction, I think. There was a note about St. Anthony's parking lot. Said I raised a question about parking in the St. Anthony's lot. I think that was the chairman who raised that.
Yeah, it was.
I will fix that.
But I wanted to give you credit, Dave, for,
He was glad you brought it up.
yeah, glad you brought it up. Okay, I'll try again later.
All right, so we have
It's kind of a stupid point, so that's why I wanted to
Give it to me.
reflect it.
so we have a move as amended.
Okay, it's, so it's been approved as amended.
We just need a vote. We had my Dickey.
Oh, I'm
moved.
sorry. Well, yeah, we didn't approve it. I make a motion to approve the meeting minutes of July 13th.
As
As
amended.
amended.
I'll second that, Woody.
All right, moved and seconded, all in favor? Just aye.
Aye.
Okay, anything exciting, Jen, coming down, or are we going to have a quiet September?
We'll see. I think I'm getting one small application, maybe two, but we'll see what comes in. I'm off tomorrow. I'll be back on Thursday. We'll see what's waiting for me.
Okay,
I'll let you all know. And thank you, Cindy.
My pleasure.
thank you very much. Thanks,
Jen?
everybody.
Yes.
Jen? I submitted my application for reappointment online. Do
Okay.
you know when that happens?
Well, I saw that it was on this evening, but since you're all here, I don't know what happened. So I know Lee and so let me check with Tracy and I'll find out.
Oh, okay. Thanks.
Okay. You're welcome. All right.
All right, you guys.
Good night.
See you in a month.